Hello, I'm Dr. John Picton, and in this equity short, I'm talking about AIB Group and Redler. In the case, a Mr. and Mrs. Sondy sought a mortgage for their family home in Surrey. They applied successfully to AIB, that is Allied Irish Banks, for a 3.3 million loan. At the time, their family home was valued at 4.75 million. It was actually part of a number of mortgages. They ran a care home business and they were also up for mortgage, but those businesses are not part of this case. There was already a first legal charge on the property to Barclays Bank. And so the 3.3 million was intended to pay off that Barclays charge and then replace it with a new one to AIB Group. A firm of solicitors called Mark Redler Solicitors were instructed for this transaction. But things went wrong. Redlers, the solicitors, only paid off a portion of the existing Barclays charge. The Barclays charge was across 2 accounts, and Redlers only paid off 1 account. Redlers paid the rest of the money to the Sondys, who it appears got a windfall which they did not pay back. They, however, are not under scrutiny in this case, partly because, or entirely because, they're insolvent. So you can kind of set that bit of information just to one side. Aware that there was a problem, AIB and Barclays then went into negotiations. Barclays consented to a second charge on the property. But both AIB and Barclays recognised the primacy of the Barclays charge worth £273,000. That is, the Barclays charge would be the first to receive funds on a repossession and sale. You can probably guess what happened next. The Sondys defaulted, and on repossession and sale, the house only raised 1.2 million. This was much less than the 4.25 million valuation. AIB only got 877,000 of their money back. An odd thing about the case is that we're never told in the report why the house was so overvalued. But regardless, AIB were left looking to recoup their losses. And AIB took Redler all the way to the Supreme Court. Redler had held AIB's 3.3 million on trust. This is normal. Solicitors almost always hold their clients' property on trust. So AIB sued Redlers for breach of that trust, that is, not doing as they were instructed. AIB claimed that because there was a breach of trust, Redlers should be liable for the full 3.3 million advanced, minus the 877,000 that they'd already got from the sale of the Sondys property. Redler, the solicitors, accepted there was a breach of trust, but claimed that AIB should only be entitled to what the breach had actually cost them. That is, the value of the Barclays charge, 273,000. Redlers claimed that they were only liable for the value of the Barclays charge, which was actually lost to AIB in consequence, that is, caused by Redlers failing to clear that first legal charge. In the Supreme Court, the 2 judges which gave reasoned judgments, Lord Toulson and Lord Reid, looked back to a case from 1995, very well known case, Target Holdings and Redferns. I've also done an equity short on Target Holdings and Redferns, which you can see on the playlist. On the face of it, the case worked strongly in Redler's favour. In Target Holdings, a solicitor's firm was in breach of trust because it had paid away money to a third party. However, at least as the court understood the facts, that payment to a third party had actually not caused any loss. In Target Holdings, the solicitors had, in a roundabout way, completed their instructions. They had secured a charge over 60 to 64 Great Hampton Street, that's the picture on the screen, for the lenders. Great Hampton Street is in Birmingham. It's a very fine arts and crafts building. So Target Holdings then, and how it's relevant for this equity short, is authority for the proposition that where a breach does not cause a loss, that is a breach of trust, then there'll be no liability for the trustee in breach. Remember though, in Target Holdings, the breach didn't cause the loss because the solicitors in that case, which was called Redferns, had actually fulfilled their instructions. They did secure a charge on the building on the screen. In AIB Group and Redler, AIB Group attempted a reinterpretation of Target. As I said, in that case, the firm of solicitors had in fact ended the transaction with their instructions completed. That is, there was a charge attached to 60 to 64 Great Hampton Street in Birmingham. And so it was argued in AIB Group and Redler that because the breach had been made good in Target, it could be distinguished from the present case. Here, Redler's had never completed their instructions because Barclays had a charge left in place. So the case was distinguished from Target. The Supreme Court in AIB and Redler, though, rejected this distinction. It would, after all, have narrowed down the ratio in Target Holdings significantly, leaving it applicable only to those cases where the breach had not in some way been made good. Remember, in Target, the charge actually was secured on the property. In this case, the Barclays charge, was left in place. So the instructions weren't completed in this case, whereas they were, in a sense, completed in Target Holdings. In this case, it was indeed held, in line with Target Holdings, that Redler were liable only for losses caused. So the ratio in Target is applied in this case pretty much directly. That is, Redler were liable for £273,000. That's the value of the uncleared charge, not the full 3.3 million, which had been the subject of the trust. So AIB and Redler is significant for affirming that trustees in breach are only liable for losses that they actually cause. It doesn't matter whether or not the transaction is completed in some sense or not. That was the attempted distinction with Target. However, the case is also significant for comments Lord Toulson and Lord Reid make about the relationship of equity to the common law. Lord Toulson says, 140 years after the Judicature Act 1873, the stitching together of equity and the common law continues to cause problems at the seams. What he means is that liability in breach of trust cases remains substantially different from liability in much of the common law. The case affirms that liability in breach of trust cases remains distinct from liability across the common law, as that's broadly understood. At common law, there are legal tests which go some way to protect defendants from claimants. For example, at common law, a defendant might say that a loss was not foreseeable and so he or she should not be liable. Or at common law, a defendant might say that there was contributory negligence, which should reduce liability. This case, AIB Group and Redler, affirms that defendant trustees do not enjoy these extra protections when they are in breach. They cannot claim that the loss was not foreseeable or that there was contributory negligence. The only protection that a defendant trustee has in a breach of trust case is the claim that his or her breach did not cause the loss. And indeed, Redler here were held liable only for the loss they caused. The requirement that the loss is caused by breach is a protection for defendants in breach of trust cases. After all, in this case, Redler's escaped quite a lot of liability. And so it remains the case then that nearly 150 years now after the Judicature Acts, the common law and equity, although closely related and intertwined, remain broadly distinct.